All right, let's see if Judge Bruns leaves us. Not yet. Okay.
Not
This
yet.
morning he kept popping out and popping back in. Okay, welcome to the afternoon session of the Kansas Court of Appeals. We're happy you were able to join us by Zoom today. This is just the third time our court has sat by Zoom, but for this month, we're actually setting for the next 3 more days in a row. We'll have different panels every day, and my anticipation is that from now through the end of the year, we'll probably just be doing Zoom oral arguments. With that, I'd like to introduce you to the panel. To my right is Judge David Bruns, who's been on the court, really came on the court about 6 months, four to 6 months from each other. We've been on about 9 years. To my left is Judge Kim Schroeder, and he harkens from Hugoton, where he was a trial judge. Judge Bruns was a trial judge in Shawnee County, and I was a municipal judge in Overland Park before coming on the Court of Appeals. You'll each have 50, I don't see that there's any additional time on this case. You'll each have 15 minutes to argue. Were the appellees wanting to split their time with each other, or is just one of you?
Yes, Judge, I think I'm going to take 9 minutes for Dr. Porter, and Greg's going to take the remaining time for Dr. Resch.
And I'm sorry, Greg is taking how long?
The remaining 6 minutes.
Oh, 6, okay. All right, and Mr. Schultz, did you want to reserve any time for rebuttal?
Yes, I'd go about 10 minutes at first and reserve 5 minutes if that's okay.
Okay, 10 and 5. All right, so I didn't formally have you announce your appearances, but if you do so, I'd appreciate it. First, we'll start with the appellant.
Okay, this is Craig Schultz on behalf of Reeford Acord, who is the appellant, the plaintiff in this case.
Good afternoon, Your Honor, and may it please the court and counsel, Matthew Spahn from the Martin Pringle firm on behalf of Dr. Scott Porter.
Okay.
Your Honor, Gregory Young on behalf of Dr. Tom Resch. And just for, we're having a little trouble hearing Mr. Spahn. We hear everybody else fine. I didn't know if anybody else had the same issue or not.
His voice was a little low. I could hear him because I've turned up my volume on my, maybe you might want to.
Is this any better?
Yeah, that's a little better.
Okay, I'll just scoot as close as I can to the mic.
Okay. We know the facts of your case. We've read your briefs and we've actually looked through a lot of the record in the case. So typically we don't have you go through the facts, but because there may be other people watching, Mr. Schultz, I'll allow you the first maybe 2 minutes or so just to do a brief summary of the facts, and I won't count that against your 15 minutes, and then I'll start your time. So whenever you are ready to begin.
Very good. Well, Your Honor, Reeford Acord, this case started back in 2013 when he went into the hospital for what was planned to be a short stay, a surgery to repair his ventral hernia. He had had 3 prior repairs. The first 2 were done by a doctor who is not necessary for this appeal. The third was done by Dr. Scott Porter, who is one of the appellees defendants in this case. And that third surgery had not been successful. And so they were going to go in and repair it, if you will, by utilizing more mesh. And Dr. Porter assured Mr. Acord that they would be able to get this resolved and have a successful surgery. He went in on a Monday thinking that he would be out probably by Monday afternoon or at the very latest by Tuesday morning. And unfortunately, he did not get out. He basically spent most of the next 12 months in the hospital because during the course of the surgery, his bowel was severed and the surgeons did not recognize that they had done that. Dr. Porter was the surgeon who was elected and chosen very specifically by Reeford Acord to do this surgery. And there is a release that is signed by Mr. Acord, who and authorizing very specifically Dr. Porter to do the surgery. Unbeknownst to him, however, to Mr. Acord, Dr. Porter invited a resident surgeon in training to come in and perform the majority of the procedure. That was not discovered by Mr. Acord until nearly 2 years after the surgery, when he had come to our office and we got some medical records and began to look into this and discovered that the surgeon was actually, who did the surgery was actually Dr. Resch. And that's what brings us here. In part, we believe and made allegations that the surgery was negligently performed, but the initial allegation was that there was a lack of informed consent allowing any significant participation by Dr. Resch, but that claim ultimately was ruled out on summary judgment by the lower court. It's a very complicated procedure. Judge Leahy originally was assigned to the case. He's the one that granted the summary judgment. Ultimately, he decided to retire very shortly before the scheduled trial date. The case was reassigned and ultimately got continued a couple of times for a short period, and ultimately was tried before Judge Comer. And so I guess he gets somewhat the brunt of the arguments that are being made here. This case starts clear back, or what happened in this case has been forbidden for a long time. Justice Cardozo, everybody knows who he is, stated in 1914, every human being of adult years and sound mind has a right to determine what shall be done with his own body, and a surgeon who performs an operation without his patient's consent commits an assault for which he is liable in damages. That's from a case of Schoellendorf versus Society of New York Hospital. In this particular instance, there is a release that very specifically, as I said, authorizes Dr. Porter to do this laparoscopic hernia repair. Dr. Porter was familiar, presumably, with the insides. He'd done CT scans, he'd done preparation, he knew, if you will, Mr. Acord. And when the authorization came out, it says, I authorize Dr. Porter. There is a provision on the second page of that that's part of the record on appeal, and it says, the names of others who may perform significant portions of this treatment or procedure are described above, and there are no other names. Dr. Porter at least admitted that he had not spoken with Mr. Acord about utilizing Dr. Resch. Dr. Resch suggests that he actually introduced himself to the patient before the surgery. Mr. Acord has no recollection of that. His wife has no recollection of that and basically deny that it happened. But that's really sort of a red herring in that clearly Dr. Resch made no revelation to him at that point in time that he was something other than a resident, nor did he suggest that he had been invited to participate in the surgery. So even if he introduced himself, that becomes rather moot, because they go into the surgery and this all goes bad. Dr. Porter—
Before we get there, counsel, he also signed these conditions of admission and consent for surgical or other procedure. And I just want to make clear whether there's any dispute about whether he signed those in advance of the surgery.
No, he signed those, but that was not fair to say it's in advance of the surgery. It was certainly before, but it was like 12 or 13 days when he went in to have an EKG at the hospital. The dating is completely different, and I apologize, I don't remember exactly how many days it was, but the conditions of admission were for a different procedure. And they've tried to utilize that and tried to ask, or in fact did ask Mr. Acord about that. But that's just a general thing. Frankly, if you read it, it's like 5 pages of financial. It's all trying to make sure the hospital gets paid. when you jump over to the surgery, they have a very specific and very particular consent form, and that's the one that he signed that authorized Dr. Porter to do this.
But didn't he sign one of those documents on the morning of March 15th, which was the date of the surgery? And that's called a consent for surgical or other procedure that says, quote, other healthcare practitioners may participate in performing the procedure.
Yeah, he did sign that, and that's what it said. But Your Honor, that's like saying, I mean, clearly they know there's going to be anesthesias, there's going to be nurses, there's going to be somebody cleaning tools, handing tools to a surgeon. That's what that means. And that's why the provision goes further and it says, you know, not just other healthcare practitioners are going to participate, but if they're going to do any significant portion, then their name's going to be included. This is not some authorization that in any sense can fairly be dumped against Mr. Acord to say, well, you signed this so anybody that wants to show up and do the surgery can do it. That is simply wrong. And
is there a dispute? Is there a dispute about him knowing that this was a teaching facility?
You know, I don't think that ever has really been a huge issue. Wesley does not advertise that it's a teaching facility. Some of their forms talk about other residents and whatnot, but they act like this is, if you went to a teaching facility, automatically you're just stuck with whoever they want to bring in to do your surgery, and that's not accurate, not fair. And
but what I'm trying to figure out is whether there was I understand what you're saying about somebody else doing it, but I wanted to know if there was a dispute regarding whether he knew that residents could be involved in his care and treatment.
I don't think he knew that.
Okay.
I don't recall. I hope I'm not misrepresenting anything. I don't recall that there was really any sense in which he knew that.
Okay.
But again, it becomes rather moot because why did, for example, they not tell him very specifically what was going to happen? Why did they frankly not tell him for 2 years? He was in the hospital. I say a year. I mean, he moved from different facilities, but he was almost a calendar year, if I remember correctly, that he was in the hospital. Dr. Resch saw him every day after this for 30 or 60 or 90 days while he was finishing that particular rotation. Not one word ever said about, you know, I actually did the majority of this surgery. And I don't know what happened. I cut the bowel. Not a word like that. And so Dr. Porter's gone for the first week on vacation, and he comes back still not anything. If this was all,
but does he? Let me interrupt for just a second. So let's just assume all of that is correct, that he did not know that this resident was going to perform the surgery. Are there specific damages related to that? I mean, were you able to establish that, but for if he had been, what were the damages related to? Would the result have been different?
If the presumption in his mind, which is what counts, he gets to hire who he wants to hire. And the presumption is that if Dr. Porter had been doing the majority of this surgery, in fact, exclusively doing the surgery, that he would have known what was going on. He would have been able to either not cut the bowel, or had he cut the bowel, had it been cut, would have recognized it. He knows.
Was there evidence that he did not know what was going on, that he wasn't participating? From what I read, I thought it said he was fully participating. It took 2 people to do this surgery.
Well, he never said anything to Mr. Acord about needing 2 people to do the surgery. Yes, the evidence would suggest that he was in the operating room throughout the procedure. I can't deny that. But that's not, again, that's not the point. This case, among other issues, the critical issue here is, are you going to, if you affirm this decision, you in effect are saying that patients in Kansas who go to the hospital, who choose a doctor deliberately, identify specifically who they're going to have do what needs to be done, that doctor can change his mind and let somebody else take it over. And that is something that would be horrendous for this state, much less anywhere else. Now, your question about damages is an interesting one, because the law is really fairly clear that if it goes wrong, they become liable for it. The jury can determine what the damages are. It's impossible for a plaintiff to show that if one doctor had done this or one doctor had not done something else, that a different result absolutely would have occurred. But you've got to remember, the law is very clear in Kansas that he has a choice to even maybe not have the surgery. So the question is, and because there is simply no doubt right now that Mr. Acord would be way better off today had he not had this surgery. This was not an emergency. He could wear a belt, he could wear a whatever you call it, and hold his abdomen in. He would be so much better off. And that was his alternative. If Dr. Porter had said to him, hey, by the way, and I put this in the brief, and I'm sure you've read it, so I don't mean to be insulting about that. But, this is if Dr. Porter had said, for example, what our expert testified, that, gee, this is a very difficult surgery. It is not a surgery for a resident to perform. It's not this, it's not that. Oh, but what the heck, I'm going to have a resident do it. You want to still go forward with this? No question that from an objective point of view, Mr. Acord would have been within his rights, and most probably, if not absolutely, would have said, no, I'm not going to do that. I mean, we don't have to think very hard to go, one guy's saying this is a tough surgery, not for a resident, but I'm going to let a resident do it. No, I mean, that's just simply not going to happen. And so the law is really pretty clear. And the solution to this is not the big problem that they want to suggest. The doctor has the key to eliminating the risk, because all he has to do is sit down with Mr. Acord and say, by the way, I'd like to have a resident participate. I'm going to let him do the majority of the surgery. I'll be watching. Are you okay with that? Now, I think Mr. Acord would have said, no, I'm not okay with that, but he has the right to choose that. And so Dr. Porter, same thing, Dr. Resch, he could have come in and said, by the way, I'm only a resident, but I'm going to kind of take over and do this thing. And clearly, again, Mr. Acord would have said no. They chose not to. So they're the ones that take the gamble, if you will, in the law, and they become liable for the damages that flow from that.
Okay.
And we don't have.
Counsel, since you're, limited on time, I wanted to ask you to make sure I understand your claims here. You're making a claim of lack of informed consent, correct?
Well, on selection of doctor, yes.
Right. And are you claiming strict liability? In your brief, you hinted at strict liability. And so are you claiming that we should create new law in Kansas and establish strict liability for this situation? Or does it fall under general law of informed consent as first laid out in Nathanson?
No, I think it's basically, you've got to, I apologize, I'm looking at a note here off to the side, but they're symptomatic, if you will, symptomatic informed consent. In other words, gee, it's possible that we would cut a bowel in a surgery. And if it happens, then it becomes obligatory on the plaintiff to prove and show that happened negligently or wasn't repaired. Now, we had that claim as part of it, which, and just as an aside, because I think my time's going to be out here pretty quick, I will say.
Yeah, your time. I'm just letting you answer his question.
Okay. But this is different. This is in the selection of a surgeon. And so, for example, if he's sitting there with a ventral hernia in the hospital and some other surgeon walks up and just says to Dr. Porter, hey, let me take this case. I'll go do it. And the patient doesn't even know, as Mr. Acord didn't in this case. Can he come back and say, well, yeah, the doctor does it, it goes right, and he goes, well, it could have gone bad anyway. I mean, so in a sense, the answer is yes. We are very clearly, we don't think you're making new law. We think you're establishing the law in Kansas that they became liable for the damages that resulted here.
But specifically, are you making a claim for strict liability, which of course is different than negligence?
Well, it's different than negligence because we're saying we don't have to prove negligence. Now this is what I'm trying to clarify. We made a second argument that they were negligent. And even on that standard, had the judge let us put in the evidence, a lot of which he kept out, we would have proven negligence, or at least presented a good question to the jury about that. But absolutely, we're saying on the informed consent, when they commit an assault and a battery, this is AMA guidelines. This is American College of the Surgeons stuff that says you can't do this without taking on the risk. But if I hate to equate it to criminal law, but if I slug somebody in the face, it's a little hard for me to say, well, yeah, but I didn't intend for that to happen, or you should have made a better recovery or whatever. I become liable. That's exactly what happened here. What do you call that, strict liability, or I'm not a products liability expert, so that's the reason that.
Okay.
Thank you.
Thank you. Mr. Spahn, I think you were going to go next.
Yes, thank you, Your Honor. May it please the court and counsel. And just to clear up a couple of things based on questions you presented to Mr. Schultz at the outset, I think a question was posed about whether there was any dispute about this being a teaching facility and whether residents might be involved. I don't believe that we, on the summary judgment record, really got into the history of Wesley and whether this was a teaching hospital, but I believe the evidence showed that during Mr. Acord's prior surgeries that he had that residents were involved with those, whether he was aware of that or not. I'm sitting here today, couldn't tell you, Your Honor. And then with respect to the last line of questioning, I think that that's really the most important part of what we're here to talk about today, is that plaintiff's claim for informed consent in this case was trying to fit a square peg into a round hole, and we really don't recognize the cause of action that's being asserted here today, especially in the context of what plaintiff is requesting, which is strict liability. He's requesting that I don't have to prove causation whatsoever, but the second I wasn't told that a resident was going to be involved, even if everything was done correctly, I'm still entitled to all of my damages without having to prove any sort of causation. And simply put, that is not the state of the law in Kansas with respect to informed consent. Our informed
So you would agree that we would have to expand the law in Kansas as it currently exists and impose strict liability for failure of informed consent?
You would have to expand it greatly, Your Honor. Right now, there is case law from I think it's the Funky case, the Kansas Supreme Court, and they clearly say that an unrevealed risk that should have been made known must materialize. Otherwise, the omission, however unpardonable, is legally without consequence. And then our Court of Appeals in the Rojas decision and the Thomas decision took that Funky case and basically outlined a three-pronged causation analysis that we've cited in our briefing. And I believe it was that analysis that Judge Leahy and ultimately Judge Comer relied upon in granting summary judgment in this case, because as you all are well aware, the plaintiff has to first show that a material risk or danger was not told to him. And in this case, Mr. Acord was advised of all of the risks and all the material dangers, including that a valve perforation could occur. But what plaintiff is really claiming and trying to assert in this case is that Dr. Resch himself was the material risk or danger just because he happened to be a resident. And by the way, I know it's been referenced in our briefing, but just for the record, and since we're on YouTube right now, Dr. Resch was a fifth-year surgical resident, a month or two away from graduating and hanging his own shingle, so to speak. So he was a chief surgical resident at the time this occurred with a lot of experience. And frankly, at the summary judgment record, it was wholly undisputed that Dr. Resch was impeccably qualified to participate in this surgery. Now, no expert in this case, which expert testimony is required, even in an informed consent case, no expert opined that Dr. Resch's inexperience or his status as a resident was some sort of material risk or danger. So the plaintiff failed on that provision.
Counsel?
Yes, Your Honor.
As I read the briefs in this matter, it doesn't appear that they know whether it was Dr. Porter or Dr. Resch who caused the injury to the bowel. Is that correct?
Yes, Your Honor. That is
So
correct.
it could have been just as easily Dr. Porter who did it as Dr. Resch.
Yes, Your Honor. Our entire thing, I guess, argument at the time of trial was that there was no evidence when they were intraoperatively that there was some sort of bowel injury. There was no leaking bowel, something occurring where either surgeon could say, "Oh, look, there's a leaking bowel. Let me repair this." We believed it was most likely some sort of bruise or some sort of injury that then 5 days later, when Mr. Acord acutely decompensated, that's when the perforation actually opened up and started leaking days later. So neither Dr. Resch nor Dr. Porter were familiar with who could have caused that injury.
And so was the injury is the injury on the left or the right side of the body as to whether either doctor was on the right or left side of the patient during surgery?
I believe during trial, there was a discussion of where the location of the perforation itself, but I don't believe Dr. Porter or Dr. Resch had it in their memory what side they would have been standing on during the surgery.
All right. Thank you.
Yep. And so back to the causation analysis, basically, was the plaintiff advised of the material risks and dangers of the surgery? Yes. Is Dr. Resch, through expert testimony, considered to be a material risk or danger? Absolutely not. And then we have to also look at what an objectionably reasonable patient declined the surgery. And we've had some briefing on that issue, but suffice it to say that this at least the defendants believe that this issue was addressed in Mr. Acord's deposition, and he testified that he really couldn't answer what he would have done had a resident been involved. And then at the summary judgment stage, he submitted an affidavit that actually wasn't attached to summary.
Right, counsel, I want to follow up on that. That's I think you're going right where I want to ask about.
Yeah.
And that is, we have to abide by Supreme Court Rule 141, just like all of you do. Was the affidavit attached to the response to the motion for summary judgment? Can we consider it?
It was not attached, Your Honor. It was incorporated by reference in a footnote. I believe the affidavit was attached to a motion to amend for punitive damages that had been filed and argued already, and then the affidavit was not attached to the summary judgment record itself.
But are you claiming that it should not be considered, or are you claiming that you don't like the way it was done, but it was sufficiently before the court, the way it was done by presenting it on one motion and then incorporating by reference in the subsequent motion?
Sure, I think a trial court at that level has the discretion to consider it or not. I think that's what the law states. If you want something to be considered on summary judgment, you should attach it to your summary judgment response. But I believe there also is law out there indicating that the trial court does have discretion to consider, other items within the file, so to speak. And whether or not Judge Layton considered it, frankly, I don't know that it matters, because I think ultimately he relied much more on the first and third prong of the causation analysis than really the second prong, talking about an objectionably reasonable patient. But before my time runs out here, really where the informed consent claim fails is really looking at the third prong, and did the risk or danger materialize, resulting in harm to Mr. Acord? There really is no risk or danger, but I think it's critical here to point out that the plaintiff's experts were not critical of either Dr. Porter or Dr. Resch. They offered no opinions to the effect that those two surgeons were negligent by causing the bowel perforation, because they recognize that that's something that commonly occurs during some sort of abdominal procedure. They were critical of the fact that Dr. Porter and Dr. Resch may have injured the bowel at some point, and they didn't find it before they finished up the surgery. That was their criticism. And
that issue was presented to the jury?
Yes, Your Honor.
And they found no fault on that?
And they found no fault on that. And so there's really no connection between what plaintiff's claim should have been disclosed and the damages claim that they're making. The damages that they claimed in the lawsuit were that they failed to find the injury intraoperatively. That has no relationship to the information that plaintiff asserts should have been disclosed. In other words, that Dr. Resch was going to be participating in the surgery. There's not an identical case, but an analogous case in the Thomas versus Grant decision that we cite, where the plaintiff tried to link a disclosure that they claimed should have been told to him or her that wasn't really connected to the damages, and summary judgment was appropriately granted and upheld in that case on the causation analysis as well. We briefed it. There also is, I think, an outstanding question on just duty. Obviously, duty is a question of law for the court to decide. It appears that there's only been one decision in Kansas on this issue, and that Court of Appeals in the Waddell versus Woods case held, I think it's from 1999, that there was no duty to inform a patient of a surgical resident's involvement in surgery. Whether that's controlling on this matter or not, I don't know, but it's worth pointing out that there's only been one case, at least reported case, that I could find in Kansas, and that court found no duty.
Was that the Weedle case?
Yes, Your Honor.
Yeah.
Yeah, and so I don't know if, to me, it seems like the analysis performed at the district court level much more focused on the causation analysis. I think looking at it from both angles is appropriate in that there was no duty, but even if there was a duty and assuming a breach, then there is no evidence of causation. And so for that reason, it was appropriate for the district court to dismiss the informed consent claim. There was also, just very quickly, a failure to supervise claim asserted against Dr. Porter. And I think that was also appropriately dismissed at the summary judgment stage, just because that's something that requires expert testimony. And there was an expert testimony from the plaintiff's experts on the failure to supervise claim. So in the absence of expert testimony on a medical malpractice cause of action, our courts grant summary judgment in those cases.
Okay, thank you. Are there any other questions for Mr. Spahn? All right, Mr. Young.
Thank you, Your Honor. May it please the court and counsel, Gregory Young on behalf of Dr. Resch. Mr. Spahn has summarized the overall legal position for both defendants rather well. I would back up just to illustrate a few points for the court, that I think with this case, it's important to look at it step by step from a procedural standpoint, because the trial court's decision was made based on the response to our motion for summary judgment. The argument you hear now and some of the evidence that plaintiff tries to rely on wasn't even presented to the district court. And I think it's important to look at the briefing and the actual record on appeal that Judge Leahy, or the record that was available to Judge Leahy on what the claims were. Informed consent was not even a claim made when this lawsuit was filed. We get to expert witness disclosures, and the issue is failure to identify a bowel injury during the procedure. The question that the court had earlier about whether there was a dispute about whether the plaintiff knew this was a teaching institution, I thought was an interesting question. I think it's important for the court to know that the evidence the jury heard was that there's no dispute. Everyone knew that this was a teaching institution. Mr. Acord had had surgery at Wesley before, and surgery at Wesley involves resident care every time, essentially, as evidenced by the cases that have been cited on this that have been on appeal with surgery and residents involved at Wesley Medical Center. The other is the plaintiff sued 3 residents. The plaintiff sued 2 radiology residents and a surgical resident. All 3 were found not to be at fault. As Mr. Schultz pointed out, Dr. Resch took care of Mr. Acord for about 90 days after this surgery and was involved in the repair surgery with Dr. Harrison that was at issue in this case. So these discussions over time involved residents in and out of the room every day for almost a year. To somehow claim that he was not aware of it as a teaching hospital doesn't fall within the face of the evidence that the jury heard. As to the other issue that was brought up about the dating.
Counsel?
Yes, sir.
Mr. Young, so when Dr. Resch would go in, would he identify himself as a resident or as Dr. Resch?
He testified that he introduced himself and would identify himself as Dr. Resch and explain that he's a resident involved in the care of the patient. Also, every person that is there has a badge that says exactly who they are. And if you're talking globally.
But does the badge show him as Dr. Resch or Dr. Resch a resident?
Resident. It has a big badge on it that says resident on it so that there's no disputing who it is. The nurse has one that says nurse. The RT has one that says RT, whatever it would be. His badge says resident.
Okay, and I just I wasn't aware of how many times that was disclosed.
Yes. Well, and what I was going to talk about the condition for admission, again, that's not a form that Dr. Resch has the patient sign or that Dr. Porter has the patient sign. That's a form that Wesley Medical Center has every patient who goes into the hospital sign that advises them this is a teaching institution and that medical students and not fully licensed professionals may be involved in your care under the supervision of others, which is exactly what happened in this case. Even if you want to get into the details of that disclosure, Mr. Acord testified he didn't read it. He just signed it because that's what he did with the medical forms that he was given at the time of admission. As to Dr. Resch's role in this case, it's a little bit different than Dr. Porter in one regard. I was just going to point out to the court, which is the Bartell versus Brower case established that the person obligated to obtain informed consent is the supervising attending physician, there was no dispute that that's Dr. Porter in this case. That duty does not apply to Dr. Resch under that decision. And as the court has pointed out, I think the causation on informed consent is the ultimate key issue, because we have 50 years of informed consent law in Kansas that has basically fairly consistently been interpreted and applied by the Kansas courts. Mr. Schultz basically reads you a case from New York in 1914 and then cites to these other cases from other jurisdictions that don't have the same law on informed consent that we do. This case has to be analyzed under the Nathanson case, the Funky case, and the Rojas case. And ultimately, I think if the court looks at Rojas, it's very informative and illustrative on this point, which was the plaintiff alleged that Dr. Barker, the defendant surgeon, did not provide him informed consent because he failed to tell him he was going out of town on vacation right after the surgery and that he was leaving his care in somebody else's hands who may not be qualified or as good as Dr. Barker, which is who he chose to do his surgery. And the court said that there was no evidence showing Dr. Barker going on vacation had any causal relationship to the alleged injury that occurred. That's exactly the situation we have in this case. And that's why Judge Leahy made the decision he made when summary judgment was there. And so I think it's important for the court to analyze it under that structure.
Okay,
Plaintiff has raised
30 seconds. You can have about 30 seconds to
Thank
sum
you,
up.
Ron. I was just going to add, plaintiff has raised several other points that kind of dovetail off of the informed consent. And I think if the court reads the briefing, those issues are easily disposed of in favor of the defendants. Thank you for your time.
Okay. Mr. Schultz, you have I'm going to give you your 5 minutes.
Okay,
As
thank
you
you.
can see, I'm not very much of a disciplinarian when it comes to time.
Well, I guess I'll say I appreciate that. So first of all, there's no evidence that I can recall, and I guess our memories failed, but there is no evidence that Dr. Resch had anything that said resident on a tag, or there's just simply no evidence of that. But it doesn't really matter in this case because he's not the surgeon that was selected. And so there's again, I've got to emphasize two things here. First of all, at the risk of being somewhat repetitive, if the wrong doctor comes in and starts to do this surgery and does it, he becomes responsible for it. But this case gets complicated too, because, and I haven't addressed this yet, when we go to trial, somehow this gets transferred to Judge Comer, great guy, but he gets confused and starts to say, well, this is evidence that doesn't get to come into trial. So I am told that I can't ask questions, and these are in my brief, but I just said I want to talk about how prepared you were, Dr. Resch, to do this surgery and how much you knew. They object to that. The court sustained it. Then I said, do you know how much of the surgery performed? Again, sustained. When I can't even go in and ask the doctor what he remembers, what he did, how he prepared, what he looked at, and I'm not even allowed to ask him a question about that, that's wrong. Now they try to say, well, gee, you could have called him as your own witness. That's not the point. There's trial strategy that goes into this. This is a legitimate cross-examination. And basically, this guy says, well, I'm just a fifth-year resident, and so my standard is only to do what a fifth-year resident would do. And I'm not allowed to ask about that. Not allowed to ask about how much sleep he got, whether he worked the typical 100 hours before the surgery. We're not allowed to ask any of that. And
Did you attempt to ask any of those questions? I didn't see those.
Absolutely. I mean,
You asked a question about whether he had slept before surgery?
No, not specifically, because I was told I was not allowed to.
Well, wouldn't the way to handle that be that you would ask to go outside the presence of the jury and proffer some of this?
Well, with all due respect, we knew what he was going to say because I had a deposition of the guy.
But we didn't, unfortunately, and we have to rely on the record that you provide.
I respect what you're saying there, Judge, but this is like 4 weeks into this trial and he's on the witness stand. We are taking bench conferences about every 30 minutes and everybody is worn out and tired. And the judge knows exactly what it is that I'm asking about because it's been presented in all of these motions before, the motion for punitive damages, the motions against summary judgment. He knows exactly, and he sustained it. At what point do I have to say, well, Judge, I disagree with your ruling, so let's approach the bench? He knows exactly, these guys know exactly what I was asking for. It got to the point where it was almost comical that I couldn't ask. I mean, when you ask a general question, how much preparation did you do during surgery? And that's sustained. Do I have to argue with the judge? I contend that I don't. At some point, I've got to live with the rulings that he makes. And so when you look at all of this, this case wasn't even, ultimately didn't even get tried correctly in the sense of having all of the evidence available. Dr. Resch, who doesn't do anything but shows up, does a majority of the surgery, immunizes himself from any questions that challenge why he did this. Why did he, what he did, what his thought processes were. Those were all thrown out. I don't have to preserve a record by asking every single question that I had in the back of my mind.
Well, I respect, counsel, I respect the fact that you shouldn't argue with the judge, and I'm glad you didn't do that. And you're an experienced counsel. I know you wouldn't do that. But there was an order in limine, and the way when I practiced law, when there was an order in limine against me, I made sure that I proffered that evidence outside the scope of outside the presence of the jury to preserve that for the record on appeal. And that's what I'm concerned about when it comes to that issue, is whether it was really preserved for the record on appeal. I know you preserved some of the questions, but you started getting into a bunch of other questions, and that's why I asked the question.
Yeah, and fair enough, it's preserved, and then that's why I quoted in my reply brief, there's a specific case that says how you deal with motion in limine, because otherwise this could have turned into 3 more weeks of trial every time we've got to go out and do this. But at the end of the day, I've got to come back to this whole deal. You can't, if you sit, and the 3 of you will talk about this, I know that, I respect that, but when you sit and you try to think, what are we going to do? Are we going to say that a doctor without a release, and by the way, my client was asked in his deposition about the earlier conditions of admission and whether he read that. You guys, with all due respect, I mean this funny, I hope, you won't even want to read it. It's just full of financial stuff. Nobody's going to read that. But the authorization for the surgery, the day of the surgery, there was no evidence that he didn't read that, none whatsoever. And if we're going to say that in the face of a surgical consent for one doctor, another doctor can take over and do the majority of the surgery, that's horribly wrong. Whatever standard you ultimately feel like you have to give me when we retry this case, I'll have to live with that. I believe that the standard is my client would say, I wouldn't have had the surgery. So everything that happened to me is a damage that resulted from not having the surgery. And if at the end of the day, if frankly, if you affirm this, I'm just going to put it where I think it is. If you affirm this, I think we create a horrible mess because these doctors could have solved it, and they're taking advantage of the situation. They don't have any memory of what they did. They deny knowing who did what. And it puts the plaintiff in an impossible situation because, in a sense, without even ever saying it, I have to prove which doctor did what. And when they're both saying, I don't remember who did what, we're in there. The effect of it is that you're allowing the medical profession to do what all of their laws and all of the recognized law around the country, but all of their the American guidelines, American Medical Association, American College of Surgeons, all of these that say, you don't do this, and when you do, you're liable. So that's where this thing stands. And with all due respect, we ask you to reverse this case.
Thank you very much.
Thank you.
We will be taking this matter under advisement. Our internal rule is that we will get all opinions out and filed so that you can see them within 60 days of today. This is a pretty complicated case. I can't guarantee you it's going to be in 60 days, but we're pretty good at meeting that standard. So we will conference and discuss it today and maybe another day too, and then we'll get you an opinion. So thank you very much.
Thank you very much.
Thank you all.